All right, so we are going to start with our next speaker, and we are going to be talking about queer youth, interpersonal, and legal issues. Today we have Kathleen Nacozy, who is also, among her many talents, a freelance writer and is dual licensed in Texas and Washington, and is the former Q Law Foundation program manager. So we're really lucky to have you. Thank you for coming down from Seattle, I say. And she has 6 years of in-house counsel at the Texas, I was going to put her in Tacoma, but it's actually Texas Criminal Defense Lawyers Association, and she focuses on, and one of her passions is youth issues as a Camp 10 Trees counselor for LGBTQAU. So please welcome Kathleen Nacozy.
Hi, thank you. So yes, I am Kathleen, one of the two people on this introductory slide, and I made this presentation with Brianna Mendoza, who works in the youth section of the Northwest Network. And Brianna and I volunteer with Camp 10 Trees, as Dominique just said. And Camp 10 Trees is a queer camp for queer identified youth and youth of LGBTQ families. And as one of the lawyers in that camp community, people started asking me a lot of legal questions, even outdoors at camp in the summer. And so I quickly made it a passion of mine to learn about queer youth issues. And so that's where a lot of this information comes from, and from questions that either youth or their parents have asked me. Okay. So just first I want to say that this presentation is about working with folks who are 18 and under, because that's where the law makes a distinction, and that's where a lot of the legal rights change for folks, because unfortunately if you're under the age of 18, you have much fewer rights. So we find that in a legal capacity, the issues of this age group of folks are really different and really unique, and so that's one barrier to them getting good legal services, is the things that youth may encounter in the law are very unique, and as an attorney I wasn't trained to deal with them, so that's tough. The good news is that you can speak to a youth about legal issues. That was one thing that I was concerned about right away when youth would come up alone and ask me questions, is can I talk to them without a guardian here? So you can. There's different that is different for youth seeking their own medical care, and we'll talk about that a little bit later, but youth can seek out their own legal advice. So that's great as far as our capacity is clinical attorneys for youth. Another barrier, though, is just the different access that youth may have to a clinic. So youth may prefer like a phone consult because they may not have transportation to the clinic. It may be good for us to ask them on the phone line to bring a friend with them, or to bring someone just to help them digest all the information. So there's some barriers like that that make it tough in a clinical setting to help youth. So we're working to try to minimize that. But unfortunately, youth do experience a lot of tough issues like bullying or displacement of housing, or issues around transitioning. So we're going to talk about all those, and I'm going to start with just the interpersonal barriers to helping youth, and why it may feel really different, and things just to keep in mind. First, I'm going to talk about what it's like for youth, just to be a young person and to maybe be facing a legal issue and how scary that is. If you could just think back to a second what it was really like in high school. I think often we think that those were like, our glory days, and it was so much better. But also, it's a really frightening time. There's so much change happening, and you don't have a lot of agency. And especially if you're a queer youth. Queer youth are 4 times more likely than straight identified youth to attempt suicide. It's a really tough time to be coming out as queer, maybe questioning that. So we want to keep that in mind when you're talking to youth. Like, this can be a really frightening time. They may not have a single adult in their life that they can go to and talk about issues of being queer. So yeah. I usually ask for a show of hands how many people would go back to middle school if they really had the choice. And people are shaking their heads. Yeah, I definitely would not. Now I want to talk about working with youth in particular, and like what you may project onto youth. So one stereotype that I already revealed about working with youth is, even when youth have come up and asked me legal questions, like I have this stereotype that I can't talk to them about it, that they won't understand, or that I can't talk to a youth about this without their parent there. And that's a way that I think I've been adultist. and kind of underestimated a youth's capacity to understand their own rights and to know what they want. So it's important when talking to a youth in a clinical setting to kind of check your adultism and realize that we want to empower youth and not disempower them and talk down to them and not assume that they won't know what you're talking about. So let's collectively think about stereotypes that you have about youth, and then we're going to keep going with this for a couple more slides. So the impact of stereotypes are that we tell youth many things about their experiences, or like, when I was young, this happened, or don't worry, it gets better, is that common phrase that Dan Savage popularized about working with queer youth, is just to tell them it gets better. But that's not really very helpful when someone is like 14 and they have at least 4 more years of that. So we really want to look at the youth, where they're at now, and talk about how we can help them. And so in the second half of this, we'll talk about the legal ways we can help them. And so just looking again at the impact of our stereotypes, the effects of how adults treat youth will stay with them for a long time. And as an adult, we do have that power. We have the privilege of being adults, and the youth don't. So we just want to keep that in mind. So this is a chart that Brianna made with some youth about stereotypes that they always feel are put upon them, and how we can reframe those stereotypes. Like, it may not be a bad thing that youth are risk-taking. It may, that may be like a real great thing about working with youth, is like they may be emboldened. And instead of saying they're irresponsible, we can realize that they're still learning. So by just reframing these stereotypes, I think it helps us trust that we can empower youth, and it may feel different working with youth, but that if they come to us for legal advice, or not, they definitely deserve that help and are autonomous individuals. And that we don't want to just like protect them from risk, because we won't always be there. We really want to give the youth the tools to either go on and seek other legal services, or to keep coming back to the clinic. So we want to empower youth by giving them information and also listening and respecting them. Because sometimes, just like adults that come to our clinic, so a youth may just need someone to listen to them and to acknowledge that, like, this is really hard, and like, it is really tough, and it must be scary to be a youth. So stuff like that, I think, can really help. Now we're going to move on to the legal issues. And I'm going to talk about each of these, and these are just issues unique to youth, the issues that will come up if someone is under the age of 18, and so they're treated differently by the law. So I know that Volunteer Legal Services here in Pierce County already has some clinics that deal with youth issues, which is great. Like, I know that y'all are just starting a clinic where you, you help with, can I say that into the mic? She held up a sign that said I'm talking too close to the mic. I also do stand-up comedy, so I'm used to talking loud. Like here? Is that better?
It's popping a lot of keys.
Oh, okay.
Thank you.
Okay, cool. It's wild talking in a church. I just want to add that while I'm off script. Okay. I won't laugh in here. Okay, so these are some legal issues that may come up, mostly around the fact that if someone's under 18, they lawfully need a guardian. And so there may be a lot of issues surrounding that, just trouble of issues with guardianship. So Volunteer Legal Services just started up a clinic that helps with sealing juvenile records. So that's really exciting. And we're going to talk about sealing juvenile records in the criminal issues slide. And I think there's also some other clinics that help youth dealing with maybe dependency issues. So that's really great. I'm going to give you some general things, just if youth come to you in our clinic setting or otherwise, about some of these issues generally. A dependency issue is probably the heaviest that we'll talk about, and that's when a youth is without a guardian. And this can be filed by anyone, including a youth on their own behalf, but it's usually petitioned for by the state, like someone working with CPS or DSHS, like maybe someone in the school system alerted one of these agencies that a child was being abused or being neglected. And so they would have contacted an agency, and then an agency, through their own investigation, would maybe feel that that is the case and that the youth needs different placement. And so they would file it for a dependency petition. And that's, again, when a youth has been abandoned, abused, or neglected by a person legally responsible for their care, or when the youth has no parent, guardian, or custodian capable of caring for them. And this results in permanent or substantial restriction on the parental rights and placing the custody with a relative or another suitable adult or a foster or a group home. So this may happen like, let's say a youth like came out to a parent and was under 18, and then the parent did not take the news well, and so they either started abusing the child or maybe kicked out the child. And so at that point, like maybe then that youth would come to our clinic and would maybe be without a home. And so this would be like maybe the end result would be filing a dependency petition. But then before that time, there's a more immediate cause of action, which is a CHINS petition, and that stands for Child in Need of Services. And that can be also filed by the youth, a parent, or a state agency like DSHS. And this is, again, more of like a Band-Aid for a situation. Like if a youth did come out and was kicked out of their home, they could file a CHINS petition. And so these are much more common. And so sometimes when youth have come up to me at camp, like this has been the next step, that we need to get them in some kind of temporary placement that is lawful versus the youth running away. So this is a good kind of vocabulary term to have in your mind, just a CHINS petition. And these are also often filed by like therapists who work with youth if it seems like the youth is experiencing the same things that may lead to a dependency petition, like abuse or neglect. And then like let's say a therapist would put in motion this CHINS petition, which is just a temporary placement somewhere else. And so they're again lawfully staying maybe with another adult versus unlawfully as a runaway. What else? Okay. Yeah, so it's also considered just when there's a conflict between an adult and a child. And if a child files for a CHINS petition, they will likely, hopefully, be assigned an attorney when they get to juvenile court. And I spoke to the VLS director, and she said that usually does happen in Pierce County. So that's the good news. If a youth comes to us and needs this kind of placement or petition filed, that hopefully they will get to juvenile court and be assigned an attorney. So if we can just help get a youth on their way there, then they'll hopefully have that help. And if not, they can always come back to the clinic or we can follow up. But yeah, so they'll be assigned an attorney. Whoops. But their parent or guardian may not be assigned an attorney in this case. And the parent or guardian may be like an adversarial person with them in the court who doesn't want the child taken away, just like a dependency petition. But a CHINS petition is different than a dependency petition in a lot of ways, but mostly because it is just uses a temporary measure. And so what the court is trying to do with the CHINS petition is reunite the family as quickly as possible. So they're considering this, again, just temporary. So a youth may want to then put other methods in place, like filing for emancipation, which we'll talk about, or filing a dependency petition if they really need to get away from the guardian. So this is a little more rare. This is called an at-risk youth petition or an RE petition. And this is filed only by the parent or guardian. And it's filed kind of adversarially against the youth if the guardian feels like the youth is out of their control. And so they can file this when a minor has been absent from the home for more than 72 hours without parental consent, so in the case of a runaway. Or also in the case of if a minor is beyond control because they're using like drugs or alcohol, and a parent is like legitimately worried about the youth. So a parent would file this, and then a minor will be maybe found by law enforcement and brought to court, and then the court can issue an order to kind of control the youth through this court order. And it's kind of, again, an odd circumstance where the court would set like hearing dates and the youth would have to come in and report, and maybe the court would determine that there's like a substance abuse problem that's bigger, and then the youth may have to go get treatment. So if we're looking out for youth's best interest, an RE petition is really not something that we're looking for. I think that can be a really controlling measure, that when a court has control of someone. Yeah, Julie?
So based on the second, could they use their LGBT and identify against a child and try and use an RE petition and say, their health and safety, welfare is done in a discriminatory manner because they're LGBT?
Mm-hmm. So the question was whether the parent could use probably as evidence that the youth is being unruly because they've come out as GLBT. Is that right? Yeah. And yeah, they can. They can say that the youth hasn't been following their rules and has been unruly. So yeah, they can say that. But hopefully, if they became specific about what they meant, like about the youth's identity or coming out, that the court would use their better discretion and say that that isn't just against your rules. So it might be a good thing that then there's a more, reasonable mind kind of intervening in that parent-child relationship. And I just mean, in my opinion, the reasonable mind would be more sympathetic to a child coming out. But yeah, that can definitely feel like a cause of action, I would imagine, for a guardian, that they don't want the child to be queer or out and queer. And so that's why they could seek an RA petition. So I think it definitely can be a particularized issue for a queer youth. And yeah, again, a scary issue. One of my other peers at Camp 10 Trees works with youth in a school setting and called me recently and said that a youth had run away from home after coming out of the closet to a parent, and that then the parent went to the police station and said, "Can you put a warrant out for my child's arrest because they ran away from home?" And so my friend called me to ask what the youth could do in the circumstance. And I said that, unfortunately, they had to beware of the RA petition. The parent could try to control them, and that the youth didn't have an obligation to show up at the police station unless there was a warrant out for them. But that if they were a runaway because they were staying with friends, that they would have to, you have to alert law enforcement if you're staying with a different adult. And it's the adult's responsibility. So we'll talk about that when we talk about runaways. So another option that youth have as far as guardianship is to become emancipated from a guardian. And a lot of youth talk about this and want this, but it's pretty rare that it's actually granted because the requirements are kind of particular. To file for emancipation, a youth has to be 16 years of age or older, and then just general things, like they have to be a resident of Washington. And then something that sounds general but is kind of difficult to prove, actually, is the youth has to prove that they're able to handle their own financial, personal, social, educational, and non-financial affairs. And the tricky one on that is proving that they're financially independent. And it can be really hard for a youth, especially while attending school and dealing with other obligations, to secure full-time employment. I mean, probably impossible, actually. So in order to prove that they can handle their own financial needs, they'd need something close to full-time employment, I would imagine. So I think that's hard, especially for a queer youth who may have be discriminated against by potential employers. So it would be really hard for youth to secure and then prove their own financial independence. So that's why emancipation, I think, sounds greater in theory than in practice. I haven't heard of a youth being emancipated, but again, that's in my limited knowledge. But one advocate who works with queer youth a lot told me that it's a 1 in a million chance that a youth makes it through the process. So I don't know if it's that high, but I think it is pretty rare. And I emphasize that because I think when youth come in a clinical setting or come and ask me questions, they talk a lot about emancipation and want that. But I think it can be, I just think it's kind of a long shot. So I think the more typical courses of action are a CHINS petition and then finding a more suitable guardian for the youth. But one reason emancipation is appealing to youth is because a youth can make many more strides on their transitioning process if they're emancipated, because doctors often won't treat a minor, but if a minor can show them that they're emancipated and they should be legally treated as an adult, then I think doctors are more likely to prescribe hormones or help with the transition process. And one more thing about transitioning, a youth under age 18 can't lawfully change their name unless they're emancipated. So it's another reason that it's appealing. So now we'll talk about runaway youth. I don't think a lot of adults know this, but you can't take in a minor without alerting law enforcement. So at that summer camp I work in, you sometimes ask if they can go home with counselors or talk about how scary it may be at home and ask if they can live with their favorite counselor, and the favorite counselor may think it's a great idea. But you actually can't do that without, again, involving law enforcement. So the adult involved would have to notify law enforcement within 72 hours of taking in a youth, that they have the youth. And at that point, law enforcement then notifies the youth's legal guardians or parents. So then the parents know. So there's no lawful way for a youth to just disappear from a parent. So, and of course, there's very good reasons for that. So I think it's great to have this in the back of your mind if you're a lawyer advising youth, that they can't just run away. So an adult commits the crime of unlawful harboring of a minor if they provide shelter to a minor without parental consent, know that the minor is away from the parental home without permission, and intentionally fail to release the minor to law enforcement, or fail to disclose the location of the minor to law enforcement, obstruct law enforcement from taking the minor, or assist the minor in avoiding or attempting law enforcement. So that's a pretty low standard there. I think that, in my interpretation, it's just saying if you know that the youth is away from home without parental consent, you can't harbor the youth. And it is a defense to this section if the adult with custody has custody of the minor pursuant to a court order. So without alerting the parents, if you as an adult harboring youth got the court involved and got a court order granting custody, like with a CHINS petition, then those are the exceptions. But that's why those petitions are so important, because they're really the only means in our state to get a minor away from their parents if you feel like they're being abused or neglected. So now beyond legal issues, I'm going to talk for the rest of the time about just like unique, or without guardian issues. We're going to talk about unique legal issues for youth. We talked about gender and name changes. They require a guardian signature or emancipation. And then once with a guardian's approval or with emancipation, the name and gender change processes are the same as for adults. So that's the good news, but again, the bad news is that without parental consent, a minor can't do any of these things. And that may be really frustrating to a queer youth. So one option for name changes without parental approval or emancipation is a common law name change. And that's similar to like a common law marriage, which is more commonly known. And that just means that the youth would like start using their chosen name and just using it consistently, and like putting that out to everyone in the world, especially like at school, and introducing themselves by that name. And that is considered a common law name change. And the effects of that are that a minor can use it like on employment forms and things like that. But some employers may require that that there's some like documentation of the name, because it wouldn't be on their driver's license. Like, so a minor's lawful name would still be on their driver's license and all their paperwork, but if a minor's in putting out a different name into the world, they may, be required by some agencies to show that name on paperwork. And if that's the case, then we can advise that a minor get an affidavit of name change, and that would just mean going to a notary, and the notary would just be signing a written document that says that that the minor is using this name and putting this out as their name, and they're not doing it for any fraudulent reasons. So that can be like the change there, that's all they're really swearing to, is they're not doing it, let's say, to like evade law enforcement or something. So that can be like the one way they can have that name change in writing, is with that affidavit of name change. So that's something that we can recommend. But otherwise, queer youth may be stuck in not being able to change their gender or name until they reach the age of 18. Okay, so on to doctor's care. So I'm grabbing another chart here. So generally, unless it's an emergency medical situation in the state of Washington, medical professionals will not treat someone under the age of 18 without parental consent. But there is something called the mature minor doctrine through our courts that says that if the healthcare provider deems that the minor is capable of consenting to their own healthcare, and I just want to get the language right, and they will evaluate the minor's age, intelligence, maturity, training, experience, economic independence, and general conduct as an adult, whether they can deem that minor can consent to their own health care. So again, that's called the mature minor doctrine, and that's the one loophole that may save from a youth not being able to seek their own medical care unless it's an emergency. And so that may be important if a youth is seeking hormones or is is a runaway youth and is seeking these petitions and needs medical care without having to get the guardian or the court involved. If the minor can find a doctor who believes that they're mature enough that the doctor may treat them. And it seems like, at least in Seattle from asking around, it doesn't seem common for healthcare providers in Washington, or in Seattle, excuse me, to help youth in a gender transition, without consent. Oops, sorry.
What options do you have for getting a government issue ID? If they're not able to drive, but can they get a government issue ID?
The question was what options youth have to get a government issued ID versus driver's license. And did you have something to add?
Yeah, and also if they don't have their birth certificate with them or their social security card.
Oh, that's a good addition to the question. The addition was, what are the options if they don't have their birth certificate with them or their social security card to get a government issued ID? I do not know specifically. That's such a great question. I do know, just back to the name change thing, that unfortunately would probably be in the given name by their parent. That's great. I'll look into that. I'm seeing if anything's coming to mind, but I can't think of anything. Yeah, that's another thing to consider that's really prohibitive to youth. Like, they may not have access to all their documents, and the parent may be holding that stuff hostage. So it's really tough. So barriers to medical care, that's huge, whether they're issues of transition or not. The chart I'm referring to is part of a Q law packet that was made for youth. I think it was made in 2001. That I think we're currently updating. But there's a great chart in the back of that packet that talks about what kind of health care youth can get without parental consent. So youth can get an abortion without parental consent. They can get therapeutic care. But as far as medical stuff, they can only get it if it's in an emergency. Let me see if I'm getting everything. Okay, and just to touch back on name change and gender change. So to change your name in Washington, you would need a court order, or that common law option we talked about. And so, again, the court order is not an option without the parent or guardian or without emancipation. Okay? And one more note, just back to therapy and consenting to that. So if youth are over the age 13, they can consent to their own counseling. But one barrier is youth usually can't afford their own counseling. But over age 13, they can consent to that. Moving on to another just general topic that youth may be facing is bullying. Like I said, that queer youth are 4 times more likely to attempt suicide than their straight counterparts. And just some other statistics also from an organization called Mental Health America is that GLBT youth are 2 times more likely to experiment with drugs and alcohol. And 37% of queer youth versus 67% of straight youth say that they're happy. So again, that's only 37% of queer youth say they're happy. And then one more statistic I thought was interesting, that 1/3 of the GLBT youth surveyed said that they missed a whole day of school in the past month because they felt unsafe at school. I definitely want to talk about bullying because it's a huge issue for queer youth, especially now as youth are coming out earlier. That's the good side of it. But the dark side is that then they maybe face a lot of bullying. And it may be bullying by their parents, or here I'm referring to bullying by their peers at school. So as you may know, there's no federal civil rights law in our country that covers harassment based on sexual orientation. And bullying based on gender nonconformity may be sexual harassment covered by Title IX, but that's it. Our Washington state laws are a lot better, and they protect against bullying or cyberbullying, discrimination, harassment, and intimidation, and include gender and sexual orientation as protected classes. And Washington law requires that schools adopt an anti-bullying policy that covers these protected classes that are the classes identified in Washington hate crimes law. So while that's a requirement that schools have an anti-bullying policy, there's no checks and balances for that system, and there's no structure to hold schools accountable. So who knows whether schools are doing that or how effective those processes are. There's no, Title IX officer or, gender police in schools. that are ensuring this kind of protection. But at least I know that in Seattle public schools, they have a comprehensive anti-bullying procedure that is district-wide in Seattle. And with that Seattle policy, you can do an online search and access a way to file a complaint electronically if a student is being bullied in a Seattle public school. So if a child wanted to have maybe some kind of legal recourse against bullying, they would need their guardian to file the lawsuit. And that would be like a civil lawsuit against the perpetrators of the bullying. So that isn't really a great option, just due to maybe lack of support from a guardian or lack of funds. So if a youth comes to our clinic with concerns about bullying, there's not much we can do except advise them on instigating a civil lawsuit. Sorry. Or talking to them about just then more practical measures that wouldn't be lawful measures, like switching schools or talking to a teacher or something, or talking to a guardian. If the guardian isn't intervening, that can maybe be cause for a CHINS petition, like we talked about earlier, that the child is being neglected, and that's a basic need that the child feels safe in their school. So that could definitely be an argument there. Okay, so just a bit about criminal issues. I know that we don't advise on criminal issues in our clinic, but one thing that may come up is sealing a juvenile record, and especially this may be a question when adults come through our clinic. In Washington, juvenile records are entirely open to the public, and they're not automatically just sealed or deleted when a youth turns 18. So this definitely may be haunting someone that they have this juvenile record and it's not going away, and it's a public record. So often when someone applies for a job, someone can just Google them and maybe find this public record, or they may have access to a public database with their criminal record, or just get on the court's website. So there are options to seal a juvenile record if a person meets several statutory requirements, and this would be through a petition to seal the record. And the eligibility for that depends on the seriousness of the offense, the amount of time that has passed, and any pending criminal matters and financial legal obligations, like to a court. So it's up to the court's discretion. So this may be denied, but there definitely is an avenue to try. And like I said, VLS has a clinic now that I believe is new, and that helps folks with sealing juvenile records. So that's a really exciting resource that we can refer people to. And then just general, I put on here Washington age limits for different substance use, because a common issue that youth may at least call about is if they have a violation for a minor in possession of alcohol or marijuana, because those ages are 21. And our Attorney General, Bob Ferguson, wants to make tobacco use age 21 versus age 18. So that's just something to look out for. So again, youth may call our clinic with these issues. And we can say that we don't do criminal issues, but unfortunately youth may be facing these, which would really affect their potentials for employment, and that may face emancipation and all kinds of things. Put a slide here on resources, because youth legal issues are so unique. I think that one way we can really serve youth who come to the clinic is by helping them get the right resources and following up about that. So I know that here in Pierce County, there is Team Child that VLS has already partnered up with and is very helpful and helps youth in the court system. So they're a great resource. There's also CASA, which is a court-appointed special advocate program, and they have volunteers who have provided advocacy for children in foster care in Pierce County for over 30 years. Oh, and that reminds me, so youth in the foster care system in the state of Washington, I think, are provided more legal services. They're given an attorney, starting with the dependency petition process, and then they have clinical options just for foster children to receive legal clinic advice, and again, they're usually appointed counsel pretty consistently. So I think that the youth who really fall through the cracks are the youth who are not in the foster care system. So some of these agencies help youth in foster care exclusively. including, I'm forgetting the name of it right now. I think the acronym is LFI. Anyway, but they're great organizations out there. Some of these are in Seattle, the Orion Center and Youth Care, and then there's other centers like that for youth in Olympia, but I couldn't find any for Tacoma. But in Tacoma there is CASA, which I mentioned. There's Kayak, which stands for Children and Youth Advocacy Clinic, and they help Pierce County in addition to other counties. And then again, Team Child, and then BLS with this new QLAW clinic, and then with the other youth clinics. Okay, so I think that's all I have. Does anybody have any questions? Cool. Okay, thank you.